Welcome everyone to our webinar on how to enforce and protect your trademark. My name is Sahil. I'm a lawyer at LegalVision in our trademarks team, and I'm joined today by Charlotte, who is a senior lawyer in our IP disputes team. I'm also wearing the same shirt in that photo. Before we begin, just a couple of quick housekeeping items. One, you will be emailed a copy of this webinar recording once we're done. If you have any questions at all during the webinar, please submit your questions in the chat box, and pretty please complete the survey after the webinar is finished, as that feedback is extremely important to us. It will help us improve as lawyers and as people. Today we will be discussing what trademarks are and the benefits of registering them, the trademark application process and strategies that you can implement to improve your protection, post-registration tips, relating to using your trademark and monitoring the marketplace, the opposition process before IP Australia, the non-use process before IP Australia, so in other words, what happens if you don't use your trademark, seizing counterfeit goods, sending cease and desist letters, domain name disputes relating specifically to trademarks, and then court proceedings. I'll be focusing specifically on points 1 to 5, as they primarily relate to IP Australia's processes. So in other words, protecting your trademark. Charlotte, on the other hand, will focus on points 6 to 9, as they focus more on the post-registration dispute aspect of trademarks. So in other words, enforcing your trademark. At the end of the webinar, we will be answering some of your questions. So please submit your questions through the webinar chat function, and we'll try to answer as many as we can. Cool. So moving on to the benefits of registration. So trademarks are signs used by traders to distinguish their goods and services in the marketplace. They can include things like words, logos, sounds, movements, colors, scents, tastes, essentially anything that a business uses to identify themselves in the market and is used as a badge of origin for certain goods or services. Some examples of well-known trademarks include the words David Jones, the iconic KFC logo, and of course the tagline "Just Do It" by Nike. However, for the avoidance of doubt, trademarks do not necessarily need to be well known like the brands I just mentioned, as long as they are unique. Trademarks can be used in the marketplace unregistered or registered, and although they can be used unregistered, there are major benefits to registration. For example, registration provides a trader with the exclusive right to use or authorize the use of a particular trademark. This means that the registered owner has exclusivity in Australia to use their trademark for the goods and services listed in their registration. Many consequential benefits can arise from this exclusive right, such as franchising or licensing benefits. Naturally, your brand will be more attractive to franchisees, licensees, or even buyers or investors if you're able to demonstrate that you're the sole owner of a particular brand. Registration also allows a trademark owner to enforce their rights against other traders who are using similar trademarks for the same or similar goods or services. I note there that a copycat business does not need to be using an identical name for the exact same goods and services. There is a broader test of similarity that's applied when comparing two trademarks if one of them has achieved registration. And securing that broad right really is at the crux of why businesses attain trademark registration. Without registration, businesses will find that they need to rely on other areas of law to enforce their rights against copycats. We're often approached by clients who have come across a business using a similar name to them for similar goods or services. It's causing confusion, but they're unable to rely on trademark law to assert their rights because they simply just didn't have a registered trademark. Turning now to the application process before IP Australia. So traders who are seeking trademark registration must apply through IP Australia, who is the governing body that administers and examines trademark applications. Now, within a trademark application, an applicant must include 3 key pieces of information. 1, obviously, the trademark that's being applied for. 2, the goods and services that are to be provided under that trademark. And 3, the owner of that trademark. Now, choosing the correct trademark to register is vital in ensuring that you've maximized your protection. For example, word trademarks are generally the most sought after registration, given they grant monopoly over that word, irrespective of font or stylization. However, traders should also consider filing for alternative brand assets they use, such as logos and taglines. Applicants should also then consider listing as many of their goods and services as possible. These goods and services are grouped into preset categories by IP Australia called classes. The more classes that an applicant includes, the more government fees that are applicable. However, the applicant is essentially paying for more protection because the trademark is being registered across a number of different industries. Foregoing certain classes could result in gaps in your protection, which can then be exploited by copycats. So for example, if I sell cosmetics, clothing, and musical instruments, I should consider including all of those goods in my application, which for reference would mean classes 3, 15, and 25. If I neglect class 25 for clothing, for example, I'm essentially allowing another business to then apply to register a similar trademark in that class. And then to stop them, I would need to oppose their application, which is significantly more costly than including the class in the first place. Lastly, in terms of listing the applicant details or the owner of the trademark, we recommend that the applicant is the entity that's using the trademark on a day-to-day basis, or is authorizing the use of that trademark to another user. Failure to do so could mean that your trademark registration is at risk of being removed, which I'll touch on a little later. Once you've achieved registration, once your trademark application has achieved registration before IP Australia and no opposition was filed against your trademark, there's a few things to note post-registration. So a few tips. Firstly, registered owners will obtain their registration rights from the date that their application was filed. Secondly, registered owners can advertise their registration rights by placing the registered R symbol on normally the top right-hand side of their trademark. This might ward off copycats in the marketplace, but can also be viewed as an attractive asset to consumers, investors, and potential buyers. Lastly, registered owners could then consider commercializing their trademark by licensing their rights to third parties. You should then also consider the following courses of action once you've achieved trademark registration. So you should monitor the marketplace. One of the most prudent things that an owner can do is find and take action against copycats as early as possible. This means searching social media, internet search engines, and business directories to assess whether the trademark is being used by another business for similar goods or services. The most common method of enforcing registered trademark rights against copycats involves sending a cease and desist letter, which Charlotte will touch on later. However, you can also then consider applying to take down the copycat's social media accounts through Facebook and Instagram, for example. Importantly, the longer that a registered owner allows a copycat to use a similar trademark for similar goods or services, the more difficult it will be for the registered owner to enforce their rights. This is because the copycat is accruing what is called honest and concurrent use, which is a valid defense to trademark infringement. If the copycat owner adopted their trademark in good faith and there was an absence of confusion in the marketplace during that concurrent period that both traders were using that similar trademark. In summary, nip it in the bud as soon as possible. The second thing that a registered owner should consider post-registration is monitoring the business name and trademark registers. Now, although business name registers don't actually list the goods and services that a copycat business is providing, it can be a good starting point for finding that business's contact details or location, and then searching for a corresponding website. Alternatively, the trademark register will explicitly list the goods and services that that copycat trader intends to provide under that similar trademark. Now, although IP Australia will likely object to that other application, because you already have a trademark on the register that's similar, we still recommend monitoring the trademark register to ensure that some applications don't slip through. IP Australia examiners are human, they do make mistakes, but more importantly, they could have a different opinion as to what is considered similar. Lastly, oppose applications. If another trademark application is accepted by IP Australia and you believe that the trademark within that application is substantially identical or deceptively similar to your trademark, and the goods and services listed within that application are the same as or closely related to your goods and services, and there are no other factors in the applicant's favor that may have allowed them to achieve acceptance, for example, evidence of prior use of their trademark compared to yours, then you should consider opposing that other application. I'm going to touch on the opposition process now. Being opposition savvy is key in ensuring that you retain brand monopolization. If you aren't, and another similar trademark registers for similar goods or services, then you're essentially sharing a portion of the marketplace with that other trader. This would obviously affect the exclusivity of your rights and could lead to brand dilution or consumer confusion later on. Initiating an opposition before IP Australia involves filing a notice of intention to oppose within the opposition period of that other application. Now, the opposition period is a 2-month window following that trademark application being accepted and advertised by IP Australia. The status of the application that you want to oppose should appear as accepted in opposition period on the trademark register. Really important, if you do not file an opposition within that 2-month window, that other trademark will achieve registration. You then have to consider commencing court proceedings to cancel that other registration. Procedurally, once you've filed that notice of intention to oppose, you then have to substantiate your opposition with a statement of grounds and particulars. This is a document that essentially just outlines the grounds of opposition that you intend to rely on in your claim. Common grounds include that the other trademark is similar to a trademark that you've registered for similar goods and services, or that the use of the other trademark is likely to cause confusion in the marketplace because of your reputation, or that the other trademark application was filed in bad faith. For example, if you and that other owner knew each other before they filed that application. If the other applicant defends their trademark against your opposition, then the proceedings will progress to the evidence stages, whereby each party will submit evidence in support of their claim. Following this, the proceedings will then progress to the hearing stage before IP Australia, after which a decision will be made as to whether those grounds of opposition are established. Now, opposition proceedings can be a very long and costly process, so it actually might be worth contacting the other applicant to resolve the issue if you believe a resolution can be reached. This should still obviously ensure that you retain your fair share of the market though. Now, moving on to non-use. Now, whether you intend to enforce your registered rights by way of a cease and desist letter or a social media takedown or opposition proceedings before IP Australia, you should 100% ensure that your legal position is not vulnerable before doing so. And one of the most common counterclaims received by registered owners of trademarks is that their trademarks are vulnerable to removal on the basis that they aren't being used. As such, registered owners should always ensure that, 1, their trademarks are being used as is. In other words, as they appear on the trademark register. To give you an example, if your registered trademark is the word humble misfortunes, but you only ever use the word humble in your branding on its own, then your registration for humble misfortunes could be vulnerable because you're not using your trademark as is. Secondly, owners should ensure that their trademarks are being used for all of the goods and services listed within that application. It's very common for registered owners to overclaim in that initial application process. So ensure that all of your goods and services are being used. Lastly, trademarks should be used by the registered owner or an authorized user. If the registered owner of a trademark is not using that trademark, then there could be complications with demonstrating that the trademark is in use. If there's a licensing arrangement in place, the registered owner should be able to ensure that they can demonstrate some sort of quality or financial control over the authorized user's use of that trademark. Once again, if they can't, then the registration may be vulnerable to removal. If a trademark is not being used as is by the registered owner or an authorized user for all of the relevant goods or services, then a third party can consider filing to remove that trademark from the Australian Trademarks Register on one or both of the following grounds. Ground A, is that the registered owner had no intention in good faith to use that trademark in Australia in relation to the specified goods or services, and that the registered owner did not use that trademark at any time before the removal application was filed. Round B is a little bit different. The trademark has remained registered for a continuous period of 3 years, and at no time during that period did the registered owner use the trademark in Australia in good faith for those goods and services. Removal applications can be opposed in the same way that normal applications can be opposed. The stages of oppositions are actually also identical, i.e. a notice of intention to oppose is filed, a statement of grounds and particulars is filed, a notice of intention to defend is filed, and then the evidence stages and a hearing. Ensuring that a registered trademark is being used also ensures that any of a registered owner's enforcement claims are also protected. I'll now hand it over to Charlotte to discuss trademark enforcement strategies outside of AEST Australia's process in a little bit more detail.
Okay, so thanks, Sahil. I'm going to talk to you today about different enforcement action you can take to enforce and in turn protect your trademark. So the first area I'd like to talk about is seizure of counterfeit goods. Seizure of goods can be a great preventative action you can take to stop goods bearing an infringing trademark from even entering the country, and therefore stop you from suffering any damage at the outset. In order to have goods seized by customs, you need to lodge a notice of objection. This is a general notice that can last for 4 years, meaning it does not apply to any specific importers or specific goods. It can also be re-lodged after this time or cancelled throughout that duration. So after your notice has been lodged, customs can then seize any goods falling within the scope of your registration that bear a mark they consider to be substantially identical or deceptively similar to the trademark. Once seized, the trademark owner and importer will be notified, and the importer will have 10 working days to respond. If they don't respond, the goods will be deemed to have been forfeited and destroyed. If the importer disputes the seizure, the trademark owner will then have 10 working days to commence legal action. The goods will be released to the importer unless there is a court order to stop release within 20 working days of starting that legal action. So as mentioned, seizure of goods is a helpful kind of preventative action to stop you from suffering damage in the first place. It can also put trademark owners on notice of potential infringers for the future. As if an infringer has attempted to infringe your trademark once, there's a possibility that they may well intend to do that again, or they may have already done that in the past. So most importantly, it's a free option for you. However, you usually need to provide an undertaking to repay the Commonwealth for any costs associated with seizing the goods, such as storage or destruction costs. So moving on, cease and desist letters are probably the most common approach taken to enforcing a trademark, as Sahil's already mentioned. A cease and desist letter is sent to the infringer to put them on notice of their infringing conduct, because in some circumstances they may not even be aware that they're infringing your mark. It also gives the infringer an opportunity to recognise and rectify their conduct going forward. In order to commence court action in most cases, you must first take genuine steps to try and resolve the matter, which is what a cease and desist letter aims to do. You may wish to send a cease and desist letter if infringing goods are already in the market and therefore are causing you damage or likely to cause you damage. You may have already been in communication with the infringer and tried to resolve the matter yourself without any success. However, you can't send cease and desist letters out where the complaint really has no merit, meaning you can't send a letter out to a competitor who is using a mark that really isn't similar enough to constitute trademark infringement. That would be considered an unjustified threat, which is prohibited by the Trademarks Act. So things to include in a letter are details of the trademark ownership, meaning your registration details, particulars of the infringement, including what the infringing mark is, what goods or services the infringer is using the mark in conjunction with, And you may also wish to include screenshots evidencing any concerning use you've seen. You'd also include the suggested action to rectify the infringement, and you'd set a deadline for them to do so. This might include undertakings not to use the infringing mark going forward and to destroy any goods or material bearing that mark. Finally, you should include next steps if demands are not complied with, which is usually court action. So a great alternative to court action I often get asked about is domain name complaints. A person may obtain a domain name before you do, which includes a trademark that you own. This might be a cyber squatter who is trying to gouge you, or a competitor who is trying to capitalise on your reputation. So rather than commencing court proceedings, you can file a complaint under the Uniform Domain Name Dispute Resolution Policy, or the AUDRP. So the right policy will depend on whether the domain name is a .com name or a .au name. The matter will then be decided by a panel of independent persons. A domain name dispute is particularly appropriate in circumstances where the registrant is a foreign entity, as court proceedings can be difficult to enforce against foreign entities. The registrant's identity is difficult to ascertain. You may struggle in some cases to find a party's true identity. The registrant might be using a fake identity, might be in an unknown location, or might be hiding behind different shelf companies. You only need the details of the domain registrant, not their true identity, for a domain name complaint. The registrant might not have any assets to recover, so damages would be, commencing litigation to recover damages would be a futile expense for you. And finally, if you just want to obtain transfer or cancellation of the infringing domain name. However, if obtaining further relief is particularly important to you, such as damages or injunctions and so on, then this won't be the right option, as all you can achieve is cancellation or transfer. A domain name dispute is a much more cost-effective and faster alternative than court proceedings. Fees are somewhere between $2,000 and $5,000, depending on the number of disputed domains and the number of panelists chosen to resolve it. The matter can also be resolved under 3 months, which is much faster than court proceedings. So finally, moving on to court proceedings. Court action is usually the last resort to enforce your trademark, as proceedings are costly, unpredictable, and time-consuming. However, court proceedings may well be the most appropriate option, especially where you have a particularly strong case of infringement and where the defences Sahil has touched on are unlikely to succeed. Proceedings may also be appropriate where substantial damage or likelihood of damage has occurred, and it makes commercial sense for you or your business to spend the money enforcing your trademark. Where you're looking to recover damages and the other side has deep pockets, it may well make sense as well. Also, in certain circumstances, it might be an effective strategy to ward off future infringers by setting some kind of precedent and building a reputation for yourselves in the market as a business that takes their trademark rights seriously. As mentioned, court proceedings can be quite a long process. The process begins with an initiating action being filed, usually a statement of claim, setting out the details of the complaint and the relief sought. The other side will then have an opportunity to lodge a defence to the claim. Then many directions hearings will occur during the life of your matter. These are hearings where the court sets timetables and checks up on the progress of the matter. There may well be interlocutory hearings, which are mini hearings to decide procedural issues. The parties may be referred to mediation at some point in an attempt to resolve the matter themselves without the need for further court intervention. Evidence will need to be prepared for your matter. This might be expert or layperson evidence, which is set out in an affidavit. This can be a particularly costly part of the court process because it involves quite a lot of time and effort from your legal team. Finally, the matter will be heard at a final hearing and the case will be argued. Sometime after, the judge will then hand down their decision and award any costs in the matter. So while I've set out some of the disadvantages of court proceedings, it's worth noting the biggest advantage of court proceedings, which is the relief that can be awarded. So you might seek an injunction, which is an order to do or not to do something, for example, not use the infringing mark in the future. An interactive order is obviously damages, which can be awarded to compensate the successful party for their losses. And in special circumstances, the court can also award additional damages if it believes additional damages are reasonable. For example, where the infringement has been particularly egregious. Alternatively, you may seek an account of profits, where the infringer has made a profit as a result of the infringing conduct. The trademark owner may be entitled to those profits. This may be desirable where you're unable to prove that you've actually suffered loss as a result of the infringing conduct, but you become aware that the infringer has made considerable sums themselves as a result of misusing your trademark. You may seek delivery up or destruction of the goods bearing the infringing mark, which means they'll either be destroyed or provided to you. And finally, the losing party may be ordered to pay the successful party's legal costs. Obtaining a cost order does not necessarily mean that you'll recoup 100% of your legal fees. You may only obtain 50 to 75% of the actual legal costs incurred, and more in certain special circumstances. So that concludes the presentation part of our webinar. So all of the information that we've covered today is covered in our guide to protecting your brand. You can download the guide, or I believe a copy will be emailed to you after this webinar. We've also got some other webinars coming up. Corporate Governance 101, Responsibilities for New Directors, which might be really helpful for any directors we've got listening today. That's coming up on Friday the 13th of May at 11 a.m. and you can register at the link provided. So now we're going to answer some of the questions that you've submitted, or if you've continued to submit them.
Let's just have a quick look. So some questions have already been submitted. Let's just pull those up. All right, so first question. There is a company that has trademarked a name similar to the one that I want to use. They use the singular version and I want to use the plural version. The goods category is different, the logos are different. Can I use the plural version? Look, without obviously knowing what the trademarks are, it's quite difficult to hypothetically comment on this. More often than not, it really does come down to what the trademarks are, comparing the trademarks, comparing the context that the trademarks are used. However, if there is a registered trademark for a singular version of a word and you want to use the pluralized version of that word, it's highly unlikely that you'll be able to do so. The reason for that is because, as I mentioned earlier, the test for similarity is whether the trademarks are substantially identical or deceptively similar. If you chuck the word, the letter S on the end of a word, so for example, if the registered trademark is the word remote and I'm using remotes, as you can see, the two trademarks are still substantially identical. So it's very likely that consumer confusion might still occur if I was to use remotes. What it really comes down to is how different the goods and services that are being provided by each party are. So if the registered trademark for remote covers air conditioning apparatus and I'm using remotes for fish and chips, it's likely that those goods or services are quite different enough for there to not be consumer confusion. So kind of summarize my answer to that question, it's very unlikely that the plural version of a registered trademark will be acceptable unless, of course, the goods or services being provided are quite different. Let's pull up another question. What's in a name? So how unique does your name need to be for business registration and for brand, media, and socials? And what is trading as? I think that's another question for me. What's in it is how unique does your name have to be? Firstly, for business name registration or simply just using a brand asset, your name doesn't necessarily need to be unique. There's no legal requirement for a certain brand asset, such as a business name, to be unique. You can register a business name that's quite generic. You can also register a social media account for a name that's quite generic. What it really comes down to is whether that generic name is unique enough for trademark registration. There is a requirement for trademark registration that what you're applying for needs to be distinctive enough to be viewed as a badge of origin in the marketplace. What that means is people are able to identify and recognize your trademark because it's so distinctive. If it's quite generic, like Plumbing Australia for plumbing services, it's very unlikely that I, as a consumer, will recognize and identify that brand. And it's very unlikely that IP Australia will grant trademark registration for that trademark because it's kind of unfair to other traders who might want to use the words plumbing in Australia in the ordinary course of trade. So kind of answer that question, your name doesn't need to be unique for business name registration or social media accounts, but it does need to be unique for trademark registration. So keep that in mind. Might move on to another question.
I think we can both answer this one here.
Okay.
So wanting to trademark my own fashion label using my surname, can my family members sue me for this or have access to any of my profits legally? How do I stop anyone else using my name for their business in the future too? If you might want to talk about the registration aspect first.
Yeah, so registering a trademark that is a surname, it's quite an interesting thing. A lot of businesses in Australia like to use their personal name or their surname to represent their brand. What it really comes down to is, as I mentioned a bit earlier, how unique, how distinctive is that surname? So if the surname that's being applied for is quite generic, in Australia, quite generic surnames might be ones like Smith or Brown or Jones. It really just comes down to how unique that surname is. So if you're applying for Smith's Chips, and obviously there is a Smith's Chips out there, they would have faced difficulty in achieving registration initially because Smith is quite generic and Chips is quite generic for what they're applying for. If your surname is quite distinctive though, so let's just say Swarovski, that's likely going to be fine at first instance because that's not a surname that's in common use in Australia. So kind of summarize my answer there. You can apply to register a trademark for a surname as long as that surname is not in common use.
So whether your family members can sue you for this will really depend on whether they've registered the name for that category of goods or services themselves first, or whether they've been using or established a reputation in that name, in that category of goods or services before you. And that's the same answer as to whether you can stop anyone else from using the name in the future as well. It will really depend on who first used it and how large their reputation is in the market in respect to those goods or services.
I might move on to another question here that's also for me. Sorry, Charlotte.
That's right.
The question is, thanks for all this information, it's really helpful. Please, can you confirm if trademarks can be registered within the same subclasses if they are for businesses targeting a different customer base? The answer to that is it depends, obviously. But yes, two trademarks can exist. If they're the exact same trademark, for example, they can actually exist within the same class, as long as the goods or services within that class are different enough to avoid consumer confusion. So, for example, if I have the trademark for Camelback and I'm in the software space, but my software is for tracking camels in the desert, and there's another Camelback on the register, but they're registered for software for plant breeding or software for financial services. We're both in the software space. We both have the same trademark. We can likely both still coexist. And that's because the intended purpose of our goods and services are so different that it's unlikely that consumers will be confused between the two trademarks in the marketplace. So to answer that, yes, you can exist within the same class as long as it's for different purposes.
I can probably answer this one. If a word is trademarked and a different business had used that word in some capacity, can you take steps to stop that business using that word, even if they had used that word prior to you successfully obtaining the trademark? Well, the answer depends on who was using the trademark prior to you. If the other business was using that trademark before you were, in respect to the same goods or services or related goods or services, then they would have a defence of prior use if you were to try and stop them, and they might be able to remove your trademark at some point as well. So it really depends on who got there first and who's established a reputation in the market.
Oh. I might go to this one here. How do you demonstrate that your trademark is being used? I.e., is your trademark on a letterhead sufficient, or what specifically must be done to demonstrate that it's being used? Kind of relating back to my section on non-use, the three main elements are that the trademark is being used as is, which is extremely important. The trademark is being used by the owner that's listed or an authorized user, and the trademark is being used for all those goods and services. So if you can establish all three of those things, that's fantastic. It then kind of comes down to whether that use is sufficient, and kind of inspecting that use. So firstly, the use should be public use. It should be use of your goods and services, like it should be evidence that your goods and services were being provided to a consumer and not just internally. So as an example, if I am an accountant, but all I ever do is provide my business administration services, like so it's kind of accounting services internally, so I provide it to other employees within the same business, that might not be trademark use anymore, because I'm not technically providing that service externally. I might just be doing it internally for business records. Or business record keeping. So it's really important that the trademark for goods specifically is branded on those products. If I'm selling water bottles, it's important that the trademark can be seen on that water bottle, or if I'm providing services, it's important that that trademark is being advertised in relation to those services, and importantly, publicly to consumers. Should we do a few more questions?
Yeah, sure. There seem to be a few questions about how a trademark applies locally or overseas. It might be helpful to address that.
Yeah, so everything that we've talked about today does relate to trademark protection and enforcement in Australia. Obviously, those rules are likely to be a little bit different in other countries. There is an international concept of trademark registration, so there are a lot of similarities between a lot of countries. For example, trademark should be distinctive or unique in a lot of countries. The goods and services classes for each trademark application in a lot of countries is similar. It's called the NICE classification. And the application process internationally is pretty much the same in a lot of countries too. So there's something called the Madrid Protocol, which is essentially just an international trademark filing system. That's really facilitated the trademark filing system for a lot of, I think it's 120 countries, including Australia, the US, the UK, the EU, China, India. A lot of major markets are party to that Madrid Protocol. So yeah, to answer that question, although what we've spoken about today relates specifically to Australia, a lot of that can be taken internationally.
And if you have a trademark in Australia, I think there are a few questions here. It doesn't necessarily mean you'd have protection overseas. You'd need to apply overseas as well, which is what Sahil's just mentioned. You can do so through these protocols.
Cool. Question, I have been using my unregistered trademark since last year. A new business has been using their unregistered trademark only this year. I'm in the process of registering my trademark, which is in the 2-month advertising period. Should I contact the other party now, or should I wait until I receive registration? A quick comment about that. We probably wouldn't recommend contacting a third party if you don't have registration yourself. The main reason for that is because your application, firstly, you haven't achieved registration rights. So you don't have any of those rights that I touched on earlier in my presentation relating to enforcement or relating to exclusivity yet. Secondly, if you're in the 2-month advertising period right now, your trademark could be opposed. So it's important to kind of not put your best foot forward while your trademark is still vulnerable to opposition. Probably recommend just achieving registration, ensuring that your rights are definitely stronger than the other parties, and then taking action.
That's not to say that you don't have rights already. If you've established a reputation in the unregistered mark, you may be able to enforce those unregistered rights through the Australian consumer law. But as Sahil said, if you're in your opposition period, if you contact the other side and say you're infringing on the Australian consumer law by using my unregistered mark, they're likely then to oppose your trademark. So strategically, it would make sense to potentially wait, unless they're causing you significant damage. But potentially wait, and then you'll have 2 different claims for infringement, being trademark infringement and a breach of the Australian consumer law.
Yep. When do you use the TM symbol or the R symbol, and what's the difference? So the TM symbol is actually not technically a legal symbol. You can apply the TM symbol to almost any brand asset that you use, even if it has not achieved registration. It's not a legal symbol. People often use the TM symbol to indicate that they have an intention to apply for registration for that particular trademark, or that they're in the process of applying, or that they're in the process of registering it. They might be facing some difficulties. So for example, if I have Smith's chips and I've received a refusal from IP Australia, I might just chuck on the TM symbol just to ensure that people are still aware that I have that intention. The R symbol, on the other hand, is actually a legal symbol. Misuse of the R symbol is an offence. So you can only use the registered R symbol on a registered trademark. You can't really give off that false impression that you have registration. You should also not kind of give off a false impression that what you've registered is different to what you're actually applying the R symbol for. So for example, if I've registered a really fancy logo, and then I use the R symbol on just a word within that logo, that's a little bit, it's a bit of a misrepresentation of what I've actually applied to register. So really important is to use that R symbol correctly.
I think that's all the time we have for questions.
Might just move on to the next slide. So becoming a LegalVision member. I do just want to reiterate that LegalVision is a full service commercial law firm. We do much more than just protecting and enforcing trademarks. You do get access, if you sign up to our membership, to all of our lawyers, whether that's in the employment space, the business structuring space, the contract space, the immigration space, etc. What I really strongly recommend is signing up to this membership because of the many perks. So for example, you get unlimited document drafting and reviews. If you have a whole range of contracts that you need drafted, or you've received a whole range of contracts from a third party and you need that review just to ensure your legal position is not vulnerable, we can do that on an unlimited basis if you're a member. You also get unlimited legal advice consultations. You can book in today, tomorrow, not on the weekend, unfortunately, but as many times as you want, and we can answer all of your questions as long as you're a member. In terms of trademark applications and protecting your trademarks, we can actually apply for an unlimited amount of applications for you if you're a member. We can apply for your word mark, your logos, your taglines, your colors, anything that you want, as long as obviously that's in Australia or New Zealand. The only thing that's kind of just keep in mind there is that government fees will always be applicable. So yeah, I really do strongly recommend membership if you are a business that has a lot of different legal needs, because obviously we can help on an unlimited basis there. If you are interested in the membership, please request a complimentary consultation. What that essentially means is we can set up a little call with a lawyer in that field and someone in our membership team, and we can kind of just discuss your business, what your legal needs are, and come up with a solution for you. If you want to leave your contact details at the end of the webinar, you can just email that email address on the slide, and we'll get in touch. All right, so that's pretty much summarizes and concludes our trademark webinar. If you do have any more questions, please feel free to reach out to LegalVision. We're always happy to help. Otherwise, yeah, enjoy your day. If you're in Sydney, avoid the rain. Thank you.
Thank you.